on Fast and Furious. You stated in previous testimony here today that you had read the 6 wiretap applications. I too have read those wiretap applications. I come to a conclusion that is totally different than your conclusions. And that is, but I think, a sliver of the information that we're looking at, where a reasonable person would only come to the conclusion that the senior-most people within the Department of Justice did indeed know that guns were walking, that those tactics were being used. And I guess my question for you, Mr. Attorney General, those things are sealed, those wiretap applications. Nobody wants to impede an ongoing investigation or hamper prosecution opportunities. My question for you today is, would you be willing to make yourself personally available to myself and Mr. Gowdy, and in the essence of fairness, Mr. Bobby Scott and Mike Quigley, to come talk to you, sit down, and I want you to show me how you don't come to that conclusion, and I'd like to show you why I think there's a preponderance of evidence that would lead one to believe that, yes, indeed, the Department of Justice did know about this. Is that fair? Could you make yourself available?
Well,
Chairman, a parliamentary inquiry.
No,
please.
Mr.
State your
Chairman, please.
parliamentary inquiry.
Yeah, Mr. Chairman, I know the Attorney General is about to answer, but is it appropriate for members to refer to sealed documents in this Judiciary Committee room and suggest that the Attorney General makes a personal visit to members on what is sealed and should not be provided during a criminal investigation?
I simply asked if, again, please, Mr. Chairman, this should not count towards my time. I'm simply asking, there's a dispute here. This has gone on for a year and a half. Most members on this side asked about Fast and Furious. We're trying to resolve this, get to the end of it. It's hard to do in 5 minutes. I'm just asking for personal time to show you what we've seen, and for you to share with us what you've seen.
But Mr. Chairman, I again refer, these are sealed documents. I'm trying to understand, is the gentleman wanting the Attorney General to speak to sealed documents that have been leaked and then discuss it with members while there is a pending criminal investigation? Is this the appropriate approach?
Gentleman will suspend. The contents of the sealed documents may not be discussed.
that's right.
The gentleman may have his time back and will receive the remaining time that has been allotted to the gentlelady from Texas.
Is that a reasonable request? Will you sit down with us and talk about this?
Well, I don't think that under the federal law, I have an ability to talk about, as the statute says, the contents of the wiretap information.
Would you be willing to sit with us and talk about all the other pieces of evidence that we see that aren't sealed?
What?
Well, I have sat down with you on 8 separate occasions.
I'm asking for more time to sit with you personally, more than just 5 minutes, and go through this in some depth. Give us 2 hours. Well, 2 members from the Democrats, 2 on the Republican side, and go through this.
You know, with all due respect, I give you 4 hours at a crack on 8 separate occasions. I'm not sure there's an awful lot more I have to say. But here's one point I would say. You and I have both read materials that senior people in the Justice Department, as they went through that approval process, did not read. As we know,
let me go on, please. So the answer is no.
No, but
well, you're eating up my time, and I only have about 3.5 minutes left. I'd like more time. That's what I'm asking for, and you're saying no. So no, but please let me share with you why I think this is imperative. Sunday, October 17th, 11:07 p.m. Jason Weinstein sends an email to James Trusty. Do you think we should try to have Lanny participate in a press when Fast and Furious and Laura's Tucson case are unsealed? It's a tricky case given the number of guns that have walked, but it is a significant set of prosecutions. James Trustee sends back to Jason Weinstein, it's not going to be any big surprise that a bunch of U.S. guns are being used in Mexico, so I'm not sure how much grief we get for guns walking. It may be more like, finally, there are going to be people who sent guns, they're going after the people who sent guns down there. Now, you claim with passion that nobody at the senior levels of the Department of Justice prior to the death of Brian Terry knew that guns were walking, and I've got an email from Jason Weinstein using the term guns walking.
I think we went through this exercise before. That refers to wide receiver, not fast and furious.
That's not what the February 4th letter that was sent to the United States Congress said. It said that the ATF never uses those tactics.
And
never.
We said
that's not true.
And we said that letter was inaccurate. It was ultimately withdrawn. But the email that you just read, and this is important, that email referred to wide receiver. It did not refer to fast and furious. That has to be noted for the record.
No, it doesn't. It says Fast and Furious. Do you think we should try to have Lanny participate in press when Fast and Furious and Laura's Tucson case are unsealed? It's specific to Fast and Furious. That is not true, Mr. Attorney General. No. I'm happy to share it with you.
Yeah,
Can I ask unanimous consent to give you some extra time to review it?
That's fine. The Laura Tucson case refers to wide.
It says Fast and Furious. We'll let the media have it, and we'll play it out.
Laura was not involved. Laura Duffy was not involved. Laura was not involved in Fast and Furious.
The email says Fast and Furious. You say it doesn't. I've got it in black and white. Did you personally read?
I have superior knowledge.
Did you personally read Speaker Boehner's letter sent to you on May 18th, 2012?
Where's the letter at?
Yes, I got that.
Did you read it?
Yes.
Have you personally responded to the Speaker?
The Deputy Attorney General responded.
So you delegated that to James Cole?
I didn't delegate it to him. We thought it was appropriate for him to respond.
You didn't think it was appropriate for you to respond?
No, but what I've indicated in my opening statement, and I'm certainly willing to indicate right now, is that I am willing to personally engage with the 4 people who signed that letter and try to come to an accommodation so that we can get you the information that you need, consistent with what I think is our need to protect ongoing investigations. I want to be as flexible as we can, and as you said, get to the end.
I have a hard time buying that when you don't sit down with a guy like me.
Gentleman's time has expired. Gentleman's time.
Can you give me a case in United States history where a enemy combatant caught on a battlefield was tried in civilian court?
I don't know. I'd have to look at that. I think that, the determination I've made...
We're making history here, Mr. Attorney General. I'll answer it for you. The answer is no.
Well, I think...
The Galani case, he was indicted for the Cole bombing before 9/11, and I didn't object to going into federal court. But I'm telling you right now, we're making history, and we're making bad history. And let me tell you why. If bin Laden were caught tomorrow, would it be the position of this administration that he would be brought to justice?
He would certainly be brought to justice, absolutely.
Where would you try him?
Well, we'd go through our protocol, and we'd make the determination about where he should appropriately be tried.
Would you try him? Why would you take him someplace different than KSM?
Well, that might be the case. I don't know. I'm not. I'd have to look at all of the evidence, all of the. Well, he's been indicted. He's been indicted already.
Does it matter if you use the law enforcement theory or the enemy combatant theory in terms of how the case would be handled?
Well, I mean, bin Laden's an interesting case in that he's already been indicted in federal court. We have cases against him.
Right. Well, where would you put him?
It would depend on how.
Well, let me ask you this question. Okay, let me ask you this. Let's say we capture him tomorrow. When does custodial interrogation begin in his case? If we captured bin Laden tomorrow, would he be entitled to Miranda warnings at the moment of capture?
Again, I'm not. That all depends. I mean,
well, it does not depend. If you're going to prosecute anybody in civilian court, our law is clear that the moment custodial interrogation occurs, the defendant, the criminal defendant, is entitled to a lawyer and to be informed of their right to remain silent. The big problem I have is that you're criminalizing the war. That if we caught bin Laden tomorrow, we have mixed theories and we couldn't turn him over to the CIA, the FBI, or military intelligence for an interrogation on the battlefield, because now we're saying that he is subject to criminal court in the United States, and you're confusing the people fighting this war. What would you tell the military commander who captured him, would you tell him you must read him his rights and give him a lawyer? And if you didn't tell him that, would you jeopardize the prosecution in a federal court?
We have captured thousands of people on the battlefield, only a few of which have actually been given their Miranda warnings. With regard to bin Laden and the desire or the need for statements from him, the case against him at this point is so overwhelming.
Mr. Attorney General, the only point I'm making, that if we're going to use federal court as a disposition for terrorists, you take everything that comes with being in federal court. And what comes with being in federal court is that the rules in this country, unlike military law, you can have military operations, you can interrogate somebody for military intelligence purposes, and the law enforcement rights do not attach. But under domestic criminal law, the moment the person is in the hands of the United States government, they're entitled to be told they have a right to a lawyer and can remain silent. And if we go down that road, we're going to make this country less safe. That is my problem with what you have done. You're a fine man. I know you want to do everything to help this country be safe, but I think you've made a fundamental mistake here. You have taken a wartime model that will allow us flexibility when it comes to intelligence gathering, and you have compromised this country's ability to deal with people who are at war with us by interjecting into the system the possibility that they may be given the same constitutional rights as any American citizen. And the main reason that KSM is going to court apparently is because the people he decided to kill were here in America and mostly civilian, and the person going into military court decided to kill some military members overseas. I think that is a perversion of the justice system.
Gentleman from South Carolina, Mr. Gowdy is recognized.
Thank you, Mr. Chairman. General Holder, I appreciate the fact that you cannot comment on pending investigations. I do. So I wouldn't ask you that. I wish the President would also follow your advice, because when he said there's not a smidgen of corruption on national television talking about an ongoing investigation, not only did he undermine people's confidence in the efficacy of that investigation, in my judgment, he undermined your department, because you can't comment on it. I think he should have taken a pass and said the exact same thing that you said when Jimmy Jordan just asked you the question. I also want to thank you, because I think you're coming to Charleston on Friday to see our U.S. Attorney and the work that the women and men of our U.S. Attorney's office are doing in Charleston. And the U.S. Attorney in South Carolina is a wonderful friend of mine. We met on opposite sides of a death penalty case, which is a strange place for a friendship to begin. And he is an avowed progressive, and I am a conservative from the upstate of South Carolina. But we are wonderful friends, I think in part because we hold out this hope that the law will trump politics, that it is the greatest equalizing force in our country, and it is the greatest unifying force in our country. So I want to thank you for going to Charleston, and I want to ask you some questions about the rule of law and prosecutorial discretion. If a bill becomes law and there is no question with respect to its constitutionality, does the chief executive have to enforce that law?
Have to enforce it?
Yes.
The president has the constitutional responsibility to enforce the laws. And the executive branch has the responsibility of enforcing the laws.
Right. So you agree with me that if a bill passes and is signed into law and there's no allegation of a lack of constitutionality, the chief executive has to enforce that law?
I mean, we're talking about a hypothetical situation here now, and given the hypothetical that you have espoused, I would think that there would obviously be a responsibility to enforce the law.
Do you agree that there is a difference between enforcing the law and following the law?
I'm not sure I quite understand that.
Well, here's the distinction I would make. Your department is asked to enforce certain statutes, Title 18 statutes. You have prosecutorial discretion. Mm-hmm. You can decide